We talked about termination of offers before, but sometimes we have terminations of contracts too. One of those is when the subject matter of the offer or the contract is destroyed. In other words, if I make you an offer to buy your car and you wreck it tonight before you accept it, that destroys the offer. But if I make you an offer and you accept it and you wreck it tonight because we haven't completed the contract, that still destroys the contract. But there are some cases where, one, it doesn't work both ways. For instance, if the seller becomes incompetent or dies, that will terminate an offer. But if the seller has accepted the offer and it's a contract, then the seller dies or becomes incompetent, the offer can still be completed. I mean, the contract can still be completed. The seller's side can be forced to go ahead and close the deal. The mailbox rule, we know, is one of those strange rules having to do with communication of an acceptance. And illogically, anyway, it's not when you receive it, but rather when the accepted offer is put back in the mail that it's considered accepted. Another way to remember the deposited, or the idea about depositing it, is that we sometimes call the mailbox rule the deposited acceptance rule. Chapter 12, 9 questions. And I don't know if I have any, I guess it should be chapter 12 and 13. I'm not sure if I have any strict liability questions on here. Let's see if I do. Suppose that we had a question similar to this when a woman woke up and there was a burglar in her bedroom and she shot him. And the question was, whether or not she was liable. Which one of the following is a case where you would be excused from a murder. But we also heard about a case where a guy in Durham, North Carolina was prosecuted for murder, and although he was acquitted by the jury, that was a huge chance that he was taking that he was going to win that case. The jury just chose to let him go. There were burglars in his garage, and they started to run away. He said, "Stop or I'll shoot," and they didn't stop, and he shot him in the back. That could be prosecuted as a type of murder or an assault if he didn't kill him, because the guy used too much force to protect his own personal property. It'd be like my son that night, his car was being stolen, looking out the window and seeing that guy stealing his car and saying, "Stop or I'll shoot," and then shooting the guy. You're not allowed to do that. When you use when one person uses another person's name, likeness, voice, or other identifying characteristic without permission for their own benefit, usually commercial benefit, with an exception of comedy routines, we call that an appropriation, and that's a tort. To completely prove negligence and recover damages, the plaintiff must show actual and proximate causation. Remember, you have to show both. A duty of care and a breach of that duty, and an injury, loss, or damage. In the Paulsgraf case, Helen Paulsgraf lost because the court ruled the causation was not proximate. Even if it was actual, it was not proximate. There was a famous case involving intentional interference with a contractual relationship or relation in your textbook. It's an old English case called Lumley v. Guy. It had to do with Joanna Wagner, the opera singer. Okay, this question takes a little thought. Every tort, this is part of the question, every tort, A, is also a crime, true or false? Is every tort a crime? No, defamation is typically not criminal. Every tort plaintiff is represented by an attorney for the government, yes or no? Plaintiffs are represented by their own private attorney in a civil case. In a criminal case, it'd be the state, of course. Every tort lawsuit is a civil matter, and that's true. It can also be criminal, but it is a civil matter. Every tort is punishable by fine and or imprisonment? No, because we don't fine people in prison for failure to pay debts. We can find them liable and render judgment against them, and we could even put punitive damages on it, but it's not generally called a fine or imprisonment. In defamation cases, we learned that for a person to be defamed, it has to be some false statement made about them, and somebody else has to hear it or read it. We also learned that if the person defamed is a public figure, then whatever is said about them, usually it's in a must not only be false, but it is made with actual malice. In other words, they not only, it was a false statement, but they knew it was false and they printed it anyway, and they had malice in printing that. So a public figure plaintiff has the additional burden of proving actual malice. Suppose somebody is accused of committing assault on someone. Remember what an assault is. An assault is creating a fear or apprehension of immediate harmful or offensive contact. By the way, in the book, they mention fear, but they changed the wording slightly in this new textbook to mention apprehension. But anyway, you don't need to remember that. The answer has to do with the immediate harm or offensive contact. Contributory negligence as a defense in tort cases based on negligence is an absolute and complete defense. If you prove somebody was contributory negligent, they get nothing. They get nothing. There's no comparative negligence in a contributory negligence state, such as North Carolina, for instance. Chapters 16, 17, and 18, remember the chapters on business organizations, 13 questions. The sole proprietorship imposes unlimited personal liability on its owner proprietor. Now, it may also impose liability on one of its employees. An employee, for instance, who commits a tort, the sole proprietor is liable for that if the tort's committed within the scope of their employment, but it does still impose unlimited personal liability on the owner. Limited liability company is owned by its members. Double taxation is associated with C corporations. In a general partnership where all the partners are natural persons, meaning there's nobody who's also, say, you can have a general partner that's a corporation or some other form of entity. But in a general partnership where all partners are natural persons, they all have unlimited personal liability. In other words, they all have the problem of being unlimited personally liable for any debts of the company. If the company is sued and its assets are exhausted, then the creditor could go after each of the partners or all of the partners to try to collect their money. In North Carolina, it's possible for a corporation, an LLC, and by definition, a sole proprietor to have only one owner. Partnerships, by definition, have to have at least two partners. Limited partnerships have to have at least one general and at least one limited. But you can have a single-member corporation, a single-member limited liability company like the one I showed you, where I am the only member of my REMEX 1 LLC. In North Carolina, the document filed in the county where a business does business under some name other than its own name is called a Certificate of Assumed Name, also known as an Assumed Name Certificate. One of the steps in creating a North Carolina corporation is filing of the Articles of Incorporation with the Secretary of State. Corporations usually have perpetual life or duration. Most LLCs do now, but they didn't originally when the statutes were slightly different. A corporation that's incorporated in one state but does business in another is called a foreign corporation in that second state. Maximum number of shareholders that an S corporation may have is currently 100, but it used to be 35, and then it was 75. So guess what some of the answers are going to be? One of them's going to be 35, one of them's going to be 75. All you got to do is remember 100 and forget I just told you 35 and 75.